Welcome to another episode of Calm the Conflict, the Art of Resolution. In part one, we look at the before and during the mediation process, how to avoid the red flags, what happens when new information comes to light, and how to prepare before the day of mediation.
I'm David Goldberg. I am a practicing disputes lawyer and also an accredited mediator through CEDA and Eagle 500 recognised.
So David, talk me through a little bit about what parties can actually do before a mediation.
Fantastic. So definitely in advance of a mediation, they need to think about what they want at the end. Often clients will come, when the clients come to see you in the first instance, they just say, I want that paid, I want that resolved, I want that dispute resolved, and I'm bang to rights, so I'm going to win. And I think then you need to be realistic. So it's managing expectations in advance of a mediation so that clients understand that this is not a win-win scenario. This is finding, sharing the pain. Someone wins, someone loses, but it's not an adversarial situation. And also coming with the mind to find a resolution. If you're not coming with the right mindset, it's not going to work.
Yeah, because in money claims, for example, just touching on money claims, whether it's a multi-million-pound dispute, usually the party that's owed the money is going to be of the view that I want all my money. I'm owed every single penny. Why should I accept anything less?
Absolutely.
That's their starting position. And then you've got the opposition that's going to say, well, actually, we don't owe them a single penny, so we're not going to pay anything.
Yep.
So that's before the mediation.
It's exactly that. Both sides expect normally to be the come out net winner. And that's the way people go, because that's how you're focusing when you're litigating. You're going to win. I want my claim. I want my interest. I want my costs. I want to win. I want to wipe the floor. And that's a very different mindset to actually when you're coming to a mediation, you need to think actually, I understand that's the ideal, but what can I live with? Which is why I'm saying prep. Talk in advance, talk to the clients, discuss, where are their bottom lines? What do they need? Does the other side have the money? We can touch on that if you need to pay. What are the other side saying about their financial situation? If they're not paying because there's a cash flow issue, factor that in, consider that in advance. Let's not be caught by surprise on the day by saying something which is patently obvious that you as a practicing lawyer will understand. Has the other side got the money?
Let's actually keep on that track, and let's just dive deeper into that, because you've got parties where, like I said, they're owed a substantial amount of money. They've got no choice but to litigate because the other side are simply ignoring every attempt they've made to talk about this case or to talk about the matter or to pay up. So they're at that stage, and actually it's only through the process that they're beginning to realise, well, why aren't they paying? Is it because they haven't got the money to pay? So is it then worth taking a case all the way through to court where the likelihood of recovering a sum of money is less and less and less?
Absolutely. So again, that's part of the prep in advance of a mediation. So the if it's lay clients without lawyers, or the lawyers should be saying to the client, actually, if it's a corporate entity, let's look at their accounts. Let's see what their financial status is. Is it a company that's actually just about to go pop? Are they not trading, which is why they're not paying? Are there other reasons? There's no point in spending tens of thousands of pounds going to litigation and getting a Pyrrhic victory. Likewise, there's no point in going to a mediation either if the other side's got no money. Having said that, at a mediation, anything is available. Options are available. So, it's not a case of the judge has to find one side wins or loses. So at a mediation, there might be an opportunity for the parties to work together in the future on adjusted invoicing terms, slightly higher charges to cover debts that have not been done, shorter payment terms, if that's going to work. Or if there's a sister company or another company, this one is about to go pop, and we know that, and you can see what's going on, because the work is being diverted or something, then enter into a negotiation with them. There are no rules.
And what about your view on position statements? So before going into mediation, both parties will exchange what we call a position statement, and it's really more for the benefit of the mediator more than anything else. But tell us a little bit more about position statements. And
I think position statements are essential. Interestingly, where you say that it's more useful for me, you're absolutely right. It is very useful for me, but I think it's also useful for the parties, because I will say short and sweet. Okay, you may or may not exchange. Generally speaking, in mediations, the parties will exchange, and it's just a useful summary because obviously you get entrenched, you're buried in the detail, and sometimes it's useful when you're preparing. Again, this is part of the in advance of a mediation. Prepare your position statement because you'll be then thinking, how am I going to comprehensively and concisely explain to David how we want to get this over the line? Where are the strengths or weaknesses? So rather than focusing on pleading and drill down the law and the evidence, so a position statement I think is an essential tool because it's useful for me to summarize. I'll read through the pleadings, but it's useful I can gauge from your position statement and from the other side's position statement, where you want to be,
where you roughly are, or where you want
where
to
you
be.
are, where you think you are, and where the holes are. And that's my job, is to then identify the holes and then, as we've discussed, plug those holes.
And what are your thoughts on putting in, again, just talking about money claims, because I know you deal with boundary disputes and lots of other types of mediations, but when it comes to money claims, what are your thoughts about putting in a settlement figure? So, what we're willing to accept in terms of a settlement. I mean, do you think that's a good thing to put in a position statement, or do you think it's something to be revealed on the day of mediation?
I think the answer to that is this. If, generally speaking, in advance, parties will have made offers, Part 36 offers, quarter bank offers, without prejudice offers.
What if they haven't? What if they're at a stage where
if they haven't,
no offers have been made?
I think it's if position statements are to be exchanged, okay, it might be a useful tool, depending upon the amount of money at stake, to actually flag up. This is where we think
Let's say we're talking about £1 million, just a £1 million claim.
All these, I understand what you're trying to do. Good press, but I think the answer is it all turns on the facts. Okay, £1 million, 150,000, 250,000. The amount of money. If it's a big claim, I would be staggered if one side or the other had not made an offer. Okay, but if there is no offer, I can only assume that that's because the conversation we were having slightly earlier is. Actually, your client is saying there is no answer to this. There's no defence to the claim, so there's no point making an offer. Okay, and then the flip side is the other side is saying, well, there's no claim here. I've got an absolute bang to rights defence, so there's no point making offers. If that's the case, neither side is going to tip that balance in advance, but I will pick that up in the conversation I have in advance of the so the position statements will be useful. I'll get a gauge of where the parties think they are, and then I think the most important thing, I think the most useful gauge from me is that conversation with both sides the day or two before, where I say, okay, what are we going to do? Because then you will be slightly more open, and it's a conversation that can be had. Sometimes lawyers are a bit reluctant about putting stuff in writing because once it's there, it's there. So yeah.
But saying that, without the position statement itself, though, is completely without prejudice. The whole mediation process itself and what goes on in the day is completely and entirely confidential.
Yep.
So, you've touched on that before. You said what's said in that room stays in that room.
Absolutely.
It cannot leave that room. So do parties, how do you get them to open up and share any sort of secrets that they might have been keeping close to their chest?
Okay, generally speaking, not in a position statement. So that will be part of the conversation in advance, because I think that's just a really useful way to saying, look, where are we going to be going? How are we going to get this? What are your views? How flexible are you? How flexible are the other side? Oh, the other side are a complete nightmare. Fine. And then both sides say the same thing often.
And do you ever get the other side saying to you, well, actually, the reason why we haven't really done anything or paid anything is because, well, we're struggling and we're going down the pan?
I've not had that specifically, but it has come out in part of the mediation process. So I think one of the things we're going to talk about is no surprises, which we can lead on to. If one of the sides is basically saying, we have no more money, and I did a mediation not too long ago where this actually came up. So the business it was a business supplying goods and products to the other side, and they were basically, the other side had twigged that this stuff was not being supplied anymore through the industry, and they knew that things were going wrong, and the other side had to fess up and say, actually, I'm no longer doing that. The business is going to go down the pan, and that was a relevant factor. So that's obviously not something in a position statement because they don't want to be saying that.
Of course
but
not.
That's part of the conversation, and the whole point of a mediation is on the morning of the day, I have to build up a very fast rapport with people. I think we've touched on this previously. But, we can discuss that in more detail. But I need to find out who the alpha in the room is, what they really want to do. Are they looking to settle this? Are they just looking to tick a box? What are their real red lines and lines in the sand? Because every the position statement will have a red. Every position statement says we're right on this, we're right on this, we're right on this, but we're engaged. We're hoping to engage in a process because we're trying to find a resolution. That's everybody's last paragraph because it's obviously some precedent somewhere.
Thank you, David. Let's continue this conversation in part 2, where we'll delve deeper into what happens on the day of mediation and the red flags to avoid. Thank you for listening. This podcast was brought to you by Right Here Creative, a video creative agency based in Oxfordshire. Check them out at rightherecreative.co.uk.